Yesterday, 17 senators filed a bill to completely erase marijuana from federal drug law. That same week, the DEA wrapped up a hearing on a totally different plan, one that only moves it to a lower shelf. Those are not the same thing. And if you are a lawyer, a cannabis business owner, or just someone with an old conviction on your record, the difference is the whole ballgame. Here is a timeline. In April, Acting Attorney General Todd Blanche moved FDA approved, state licensed medical marijuana from Schedule 1 to Schedule 3 of the Controlled Substances Act, and he kicked off an expedited DEA hearing on whether to go further. That hearing ran from late June through July 15th. The very next day, Senate Democrats, led by Cory Booker, Chuck Schumer, and Ron Wyden, filed the Cannabis Administration and Opportunity Act. 17 senators signed on. This is not a new idea. It is the third time this exact bill has been filed since 2021, and neither of the first two got past committee. So do not mistake filed for law. We will come back to that, but the content is worth understanding because it shows you where the real fight over legal weed actually is. It is not just legal or not legal. Rescheduling, moving cannabis to Schedule 3, keeps it inside the Controlled Substances Act. It is still a federally controlled drug. It just lowers the burden of proof for some medical and research uses. This bill does something different. It orders the Attorney General to pull marijuana off the schedule entirely. And it is retroactive. It applies to pending cases and past convictions, not just future conduct. That distinction matters for three groups. First, immigration. A cannabis conviction, even a Schedule 3-1, can still trigger deportation under federal immigration law today. This bill strips that out entirely. Second, banking. Federal banks answer to federal law. A Schedule 3 drug is still a controlled substance to a bank's compliance department. Full descheduling is what moves cannabis businesses out of high risk cash territory. Third, research. Both Schedule 1 and Schedule 3 carry research restrictions that do not exist for a fully legal substance. Rescheduling is an administrative tweak. This bill takes the whole thing off the table. Here's where it gets interesting. If you have practiced criminal law, the bill orders every federal judicial district to automatically expunge federal cannabis convictions going back to 1971 within 1 year, with no filing required from the individual. Anyone with pending charges gets those charges dismissed within 30 days. And if you are currently serving a federal sentence for a cannabis only offense, you are released and your sentence vacated within 60 days. The bill also says no federal agency can deny you a benefit or pull a security clearance because of past cannabis use or a cannabis conviction. That last one is bigger than it sounds. Right now, federal employees and contractors can lose a security clearance over marijuana, even in states where it is fully legal. This bill ends that outright. Rescheduling looks forward. This bill reaches back to 1971. That is the difference between a lower shelf and a clean slate. Here is the part people miss. This bill regulates cannabis like alcohol. It builds a whole federal control system around it. It creates a federal cannabis administration inside the Treasury, modeled directly on the Federal Alcohol Administration Act. You need a federal permit to grow, manufacture, or sell across state lines. And the FDA gets a new Center for Cannabis Products to handle labeling, ingredients, and age limits. There is a federal excise tax that phases up from 10% to 25% over 5 years, and retail sales are capped at 10 ounces per transaction. That cap is backed by a mandatory track and trace system to catch product diverted into states that stay dry. Here is one genuinely novel piece. Your federal cannabis permit can be pulled for violating federal labor law, wage and hour, workplace safety, union organizing. Alcohol permits carry no such rule today. It is a deliberate choice to make legal cannabis the most labor friendly regulated industry in the country. For the business side, this bill opens up Small Business Administration loans, guarantees, and lending programs to cannabis companies that are locked out today. It rewrites the federal anti money laundering guidance so banks stop flagging every cannabis deposit as a red flag. And it bars banks from denying service to someone just because of an old, nonviolent cannabis conviction. If you have been telling clients that the Safe Banking Act is the realistic path and that the comprehensive stuff is going nowhere, you are right. But keep reading. Here is what I would tell a client who asks whether to change anything today. Do not. This bill has zero Republican co sponsors, and it is headed into a House that is already moving the other direction. This year, House appropriators added language blocking federal workers' comp from covering medical cannabis, no matter what happens with scheduling. And separately, they directed agencies to keep drug testing safety sensitive employees for marijuana, regardless of any future change in the law. Even reform advocates are split on strategy. The Drug Policy Alliance is fully behind it. Doctors for Drug Policy Reform says rescheduling alone does not fix the research and legal barriers baked into the Controlled Substances Act. And the Immigrant Defense Project warns that rescheduling, the thing actually moving through the DEA right now, does nothing for deportation risk. Even Schumer's own past bet on comprehensive reform over the narrower Safe Banking Act drew criticism from allies who wanted the achievable win first. So watch the DEA rescheduling docket. That is the process with actual momentum. This bill is a marker, a statement of what Democrats would do if they had the votes. It is not a cue to change your compliance posture, your banking relationships, or your advice to clients this year. Bottom line, cannabis is still a Schedule 1 federal drug today. State law does not change that. If you or a client has questions about a specific cannabis business, an old conviction, or an immigration case touching marijuana, that is a conversation with a lawyer who knows your specific facts, not a video. If cannabis law touches your work, follow along. Hit like, subscribe, and drop the state you are in, because how this lands depends on where you live.